Good morning, everyone, and welcome. We're pleased to have you with us today. We have one case on the docket, specially set, and we have granted the parties additional time to argue. Let me remind the appellant that you have the right to reserve up to 5 of your 20 minutes for rebuttal. So when you come to the podium after you've introduced yourself, please let us know how many minutes you wish to reserve, and we'll program the clock accordingly. Are there any announcements or introductions? Hearing none, please call the case.
Committee to Stop an Unfair Tax et al. Versus Freddie O'Connell et al.
Good morning.
Good morning. May it please the court, Kurt Clements for the appellants. I'd like to reserve 5 minutes for rebuttal.
Very good. 5 minutes, yes, sir.
The appellants in this matter filed an election contest and a petition for a declaratory judgment in the Davidson County Chancery Court seeking to prevent an increase in the sales tax of 0.5% pursuant to the Improve Act, which was approved by the voters of Davidson County in a referendum election held on November 5th, 2024. After an expedited trial in this matter, the trial court dismissed appellants a civil action finding, number one, that plaintiff's complaint was not a proper election contest, and two, that Metro's transportation improvement plan met the definition of a transit improvement plan as defined under the Improve Act. On appeal, we have raised 3 main issues. The first is whether Metro's transportation improvement plan includes projects which do not fit in the definition of a public transit system project and thus does not qualify as a transit improvement plan. Number 2, whether Metro failed to include all of the information on the ballot as required under the Improve Act. And 3, whether the plan is financially feasible as required by the Improve Act. And I'd like to address, subject to the court's questions, I would like to address each of these issues. With respect to the first issue of whether or not Metro's plan qualifies as a transit improvement plan, or sometimes called a TIP, it is our position that 80% of the plan consists of projects such as sidewalks, streets, bike lanes, signals, and affordable housing, which do not meet the definition of a transit improvement plan. And thus, either 1, the election should be declared void because the voters were misled to believe the plan could be legally funded by the surcharge, or 2, a declaratory judgment should be issued finding that Metro's plan is illegal and therefore the surcharge can no longer be collected. Under the improvement plan, a transit improvement program is defined as a program consisting of specific public transit system projects or services. Additionally, the Improvement Act states, revenue from a surcharge must be used for costs associated with the planning, engineering, development, construction, implementation, administration, management, operation, and maintenance of public transit system projects that are part of a transit improvement program. So in other words, in order for the TIP to qualify under the Improve Act, all of the projects in Metro's plan have to qualify as a public transit system project.
Why doesn't the word connectivity in the public transit system definition bring in these other programs you say are beyond the TIP?
I would say for 2 reasons, Your Honor. The first is that in describing the connectivity, it talks about connectivity to non-mass transit system transportation infrastructure. And so it specifically defines sidewalks, streets, alleys, highways, etc., as non-mass transit system projects. And so it is our position that if the legislator intended that those were to be included as part of a mass transit system project, then that would have been included in the definition of a public transit system, and it simply was not. Just using common sense, if the legislator was going to use sidewalks and streets, which is the main issue in this case, to describe a non-mass transit system, they would have also put that in, if they wanted it to be part of a public transit system, they would have put that in the definition.
But it does say, or provide connectivity to other non-mass transit infrastructure. So how do you provide connectivity to other highways and roads and streets and alleys and without doing sidewalks or better signals or things like that?
Well, so that brings me to the second reason why I think it's not included in the sidewalks and streets are not included in the definition of a public transit system. And this is what it says. It says the elements needed to provide connectivity for the transportation facility to any other non-mass transit system transportation infrastructure, including but not limited to interstates, highways, roads, streets, alleys, and sidewalks. And those elements that it refers to are facilities, structures, vehicles, or property. So in order for sidewalks and streets to fall under the definition of what can be used to connect a mass transit system to a non-mass transit system, it has to fall under the definition of one of those four words. And I think we can agree that vehicle and property, the sidewalks and streets don't fall under those two words. So that leaves facilities and structures. And I outlined this in my brief. But a structure is defined as something such as a building that is constructed. Well, sidewalks and streets are not a building. A facility is defined as something such as a hospital that is built, installed, or established to serve a particular purpose. Again, that is more so referencing a building. And obviously a sidewalk and a street are not buildings.
So Nashville's mass transit is primarily buses, correct?
That's my understanding.
So
they have some trains, yes.
So under your conception, they could build a bus shelter, could they not? Because that's a structure.
Yes.
It's part of a mass transit system.
Correct.
No sidewalk underneath it, though.
Underneath the
bus stop, the bus.
I mean, it would need a floor. I mean, they would have to have
Okay.
a floor, but I think the key here is that the Improvement Act does allow the local government to combine the surcharge with other funds when doing these projects. So if Metro, as they contend, needs to connect a bus stop to sidewalks that have already been constructed with another sidewalk, they can do that, but they have to use funds from another source. They cannot use the revenue from a surcharge.
Well, doesn't the financing plan, though, contemplate, I mean, one of the complaints here is that, well, the federal grants that might be relied on here are too unpredictable or too likely to, or unlikely to be obtained to make this a feasible project. I mean, voters are aware that that's a possibility that some of these funding sources might come elsewhere, not just from the tip.
Yes, I'm not arguing that if they get federal funding that cannot be used on the tip. What our position is if it can only be used on projects that are defined as public transit system projects. But if they have other sources, whether it's from local taxes, maybe it comes from the highway fund. I mean, the Improve Act, that this local option that is the source of contention here, was only a small part of the Improve Act, which was passed in 2017. The main part of the Improve Act was that it lowered the food tax, but increased the gas tax. And the gas tax can be used, or is to be used exclusively for the highway fund, which is for roads and bridges. So the local governments, such as Metro, were going to receive additional funding for roads and bridges. They can take that additional funding and use it with the money that they raise from a surcharge passed pursuant to the Improve Act, so they can connect their bus stops to sidewalks that have already been constructed.
The definition does mention vehicles. I'm guessing roadways leading up to a bus station would be permissible funding, or would it not?
Our position is if it's exclusively used for a bus, yes. I mean, that is, and that is mentioned in the plan, but it doesn't really outline how many lanes they're going to be, where they're going to be, or what cost is going to be for exclusive bus lanes. But just general streets and roads, again, if the legislator wanted to include streets and roads, they would have put that in the definition.
I mean,
of
it
a
sounds
public-
like under your conception here, bus as mass transit is really not eligible for this type of funding unless it's exclusive. I mean, you're talking about things that like like light rail or something like that would only be riding on the rails. It seems like you're arguing for an exclusive use of these funds without any connectivity whatsoever here. And the definition, as Judge Bennett points out, does include the word connectivity.
If you've gotten that impression, I have not done a good job here, because I am not saying that. I think it does apply to a bus system, such as Nashville has, but there is only certain things that can be constructed using the tip. You can construct sidewalks, you can construct streets, and they have other funding for that, but they have to use that other funding to construct those parts of the general transportation infrastructure. That is our position. You can construct a transport facility, as is specifically outlined in here. You can construct a building. You can use utilities. You can construct a transport support facility. You can purchase vehicles, which the plan does. It talks about buying additional buses. I think 62 additional buses. So you can construct what is exclusively used for the mass transit system. But I would respectfully submit that this was not passed in a vacuum where there was no other transportation infrastructure. Obviously, the legislator was aware that there were already streets, roads, sidewalks, etc. And if you wanted to improve your mass transit system, you could use those funds to improve that.
Yeah, so is this ultimately then a budgeting issue then? I mean, is it the complaint with the budgeting process when it comes time to spend money on these various items? If you say, well, wait a minute, you can't be using the excise or the additional tax on these types of projects when the budget comes up. Isn't that where the complaint lies?
I mean, I haven't thought about it in that manner, but yes, our position is the surcharge can only be used as the law provides. And if they need additional funding to connect sidewalks or build additional streets or whatever it is that Metro determines needs to be done, then yes, those have to come from other sources.
Yeah, but some of the proposed uses here clearly are covered by the Improved Act and
Yes.
are appropriate rationale for an increase in the sales tax. Or
A very small portion, approximately $653 million. If you look at the plan, it consists of about 6 categories, and only 2 of those deal directly with the WEGO system, which is the Nashville bus system. But everything else it's 84 miles of roads or 86 miles of sidewalks, 54 miles of new streets, 592 new signals. There's a lot of money being spent on things that have nothing to do with the mass transit system. If we were talking about,
even though buses have to stop at traffic signals.
I agree, Your Honor, they do, but those are not defined in what is a public transit system project.
Which I guess goes back to my original question about, it seems your argument is that really only certain types of mass transit projects would be eligible for this type of funding. Things that you could segregate out from the other methods of transportation, like light rail, for example, is what you're suggesting.
Well, to the extent that if you didn't have a light rail system already in place, you would have to build a light rail system, I agree. But this was not passed in a vacuum. The legislator knew there were already roads and sidewalks in these towns that may need mass transit
Counselor,
system projects.
you're almost out of time, and I want to make
Sure.
sure I want to get to the financial feasibility component here, one of your prime
Yes, Your
issues
Honor.
here. So we had an opinion from, I think it was Kraft in this case, about the financial feasibility here. You say that opinion letter is insufficient because basically the decision was made with the disclaimers that come with accountants' opinion letters, that the decision really was already made, and Kraft just assumed that was. So what would have been the appropriate way to determine or prove financial feasibility here?
But may I answer? I have
Yeah.
9 seconds. Our position is that the Improve Act requires an independent assessment that the plan is financially feasible. 20% of the funding comes from federal grants, or is supposed to come from federal grants. The Kraft CPA, their opinion did not directly address the financial feasibility of the federal grants. They just had a general statement that the plan was financially feasible.
So you're not
But-
opposed to an accountant firm looking at this issue and opining on it. You just think that here the opinion was defective.
Yes, and for this reason, if I can, Your Honor, because they took assumptions from Metro that said they found that the reliance on the federal funding was feasible. They just took that assumption. And to me, that's not independent. If you're taking the information from Metro to determine the financial feasibility of the federal funding, that's not independent as the Improve Act requires.
A few more questions.
Sure, yes,
Didn't
sir.
the state comptroller's office approve the Kraft firm to do the study?
They did, but they explicitly said that they are not approving the financial feasibility of the plan.
Right. Now, if I understood you correctly at the beginning, I think you said that if any component of this plan is not in compliance with the Improve Act, that the whole plan must fail. Is that correct? Or is it severable?
No, Your Honor. As the definition of a tip, as I've read to you, and then the requirement that the surcharge must be spent on projects and construction that's related to a public system, a public transit system project, there is no other way to interpret this. I mean, we may think that commonsensically there might be other reasons to use the funding for sidewalks, et cetera, but that's not what the statute says, and as the court knows, that we have to follow what the legislator said.
The
Doesn't
statute, oh, I'm sorry.
Doesn't the plan contemplate modifications if certain aspects become infeasible?
Yes, it does. If it becomes financially infeasible, then Metro has the option of passing another plan and submitting it to the voters for another election
So even though the
referendum.
plan may morph, you're saying that if any component of it today is not within the purview of the Improve Act, then the whole thing comes down?
Yes, Your Honor, because of that, the statute to which you're referring to doesn't talk about illegality. It just says that whether it becomes impossible or financially infeasible, then they have the route of creating another plan and then submitting it to the voters. It doesn't say that there's a second bite at the apple if their plan is illegal.
Judge Bennett?
No, you asked my question.
Oh, I must be having a good day. Okay. Thank you.
Thank you.
We'll hear from you again on rebuttal. Good morning, Senator.
Good morning, Your Honors. I'm Jeff Yarborough here with Wally Dietz and Laura Fox of Metro Legal and my colleague Bob Cooper on behalf of the appellees, the Metro defendants. May it please the court, plaintiffs are asking to throw out an election. Not based on fraud, not based on any voting irregularities, but
I think they are alleging fraud.
well,
at least what they feel is fraud.
I believe they are stating as such, but
And isn't that enough to make it an election contest?
I think that it does constitute an election contest under the statute of 2-17-101. I think that it's a different question as to whether it actually states any grounds that would warrant granting an election contest.
I didn't say that they were valid. I just said they're alleging fraud in, as I gathered, 3 different ways. One, more projects that don't fit within the definition. The placement of, let me see if I get this right. The placement of where the surcharge was placed on the ballot. They said that was buried. And the use of current cost instead of initial cost, whatever that is. And those are all elements of fraud that they've alleged, as I understand it. Is that correct?
They allege each of those as fraud, Your Honor. That is correct. I think our position would be that they are stating that there are statutory non-compliance issues that renders the presentation of the option on the ballot as a fraudulent choice. And I don't think that is the correct thing. But I think regardless of that, the more important question here is we can look at the statute, and the statute, this plan and ordinance on its face complies with the statutory requirements that are set forth in the Improve Act. Section 3206 sets forth a very specific number of requirements. The ordinance, which is Exhibit 12 in the trial exhibits, sets out how Metro went about complying with those. The trial court examined each one independently. The finance plan, the letters from the comptroller approving the procedures that were used by the independent accounting firm, as well as the independent accounting firm's letter. And so we went through all of the statutory requirements. As to the ballot language, at page 721 in the record, the court methodically goes through the language that was used in the ballot, goes through each of the statutory requirements, its length, the type of language that is used, the information that's provided, and finds it compliant. But I think more importantly, in every election scenario where the ballot language has been discussed, the ultimate question that the court asks is whether the ballot language allows the voter to be able to cast an intelligent vote. And we would submit, Your Honor, that the trial court made the right conclusion that voters reviewing this ballot were capable of casting an intelligent vote.
If, for some reason, we should say, hypothetically only, okay, sidewalks aren't included in the plan, aren't properly included in the plan, does that mean that you can use the money automatically for other things, or do you have to redraw the plan and go back to the people again?
So so Section 3205 is the one that governs the use of the surcharge revenue. If it were, and I'm happy to discuss that further, but if it were determined that these connectivity issues were not properly within the plan, I think what 3205 says is that the funds can be used for any public transit system project that's included within the plan. So the funds can be used for permissible expenses that are set forth in the plan. If there were excess funds in the surcharge that didn't, after all of the acceptable uses were filled, then the Metro would have to go back to the voters and propose additional public transit system projects in a new transit improvement plan in order to spend the dollars there.
Since you brought it up, let's go back to the word connectivity. I think what that provision means is pretty important in this case. And would you outline how you see it, how you see that word in that particular statutory provision playing out?
Yes, Your Honor. So Well, if I could, as an initial matter, I would say because the plainest definition sort of would make public transit system and mass transit system somewhat equivalent. And I think the entirety of the definition actually very deliberately and explicitly makes public transit system include the mass transit system components and then obviously much more. The second two-thirds of the bottom two-thirds of that statutory definition are beyond the mass transit system piece. The connectivity provision, it says to provide connectivity to any non-mass transit infrastructure, and then includes streets, roads, alleys, sidewalks, and other forms. So if you look, so I think the purpose of that provision, I hope, is relatively straightforward, Your Honor, is to ensure that the transit system is connective to the nearby infrastructure that people are coming from. So, I mean, if there is a nearby house and the people would have to walk through or wait for the bus in a ditch, that is not effective connectivity that allows your mass transit system to be functional. And so I believe the connectivity is intended to ensure not only that the transit system is operable, but that people can get to it and get on it. And that's consistent, Your Honor, with numerous provisions throughout Tennessee Code, such as Section 4-3-2703, which deals with the duties of the Commissioner of Transportation, and one of his key responsibilities is to ensure that the transportation system is multimodal, and it explicitly provides that part of that is improving the connectivity to pedestrian and bicycle facilities.
So how does something like affordable housing then fit into that component?
So first, Your Honor, I appreciate that question. I believe that stating that the plan would use surcharge revenue to build or operate affordable housing is not correct. The provision of the plan that it's referenced, which I believe is page 435 in your record, talks about the acquisition of property, the site preparation of land near the transit centers, which I believe is those things are within the statutory definitions of 3205 and 3201 pretty cleanly. So what the plan references at 435 is that it's going to use those projects as part of a joint development, which is what is explicitly provided for under federal law regarding capital improvement grants. And the Improve Act, by its terms, contemplates using surcharge revenue as matching funds for those joint development, for those federal grant projects. And so I think that assuming, one, that it is just that we're paying for housing in this plan is inaccurate, but the type of project that we are talking about is plainly within the purview and ambition of the Improve Act.
Well,
I'm sorry, go ahead.
Well, I was going to say, so you referenced the Federal Transit Act, and I appreciate that sort of informs the whole how we have to understand these types of projects. But our Improve Act didn't adopt the capital project. I mean, they very well said, we're going to use for our definition the capital projects definition in the Federal Transit Act. They didn't do that. We did something different. And so I worry that some of these projects really don't have any connection with all to the WEGO system and providing the connectivity. I mean, we focused a lot on that word in 3201 that we're talking about here. So, you know, I appreciate that affordable housing can have elements that make it easier to hop on a bus, but I mean, to me, that sounds really removed from items under this definition.
Well, Your Honor, I do not actually disagree with that. And do not, and I don't think it's not Metro's position that that the language is changed because of the federal act. I think the language is sufficient to provide for what is actually in the plan, which is the acquisition of property around and near these transit centers that are going to be created, and the development of those properties. But I don't think that means that that Metro can't, using other funds, engage in a joint development that leads to affordable housing. But there's nothing in this plan that says it's going to actually use dollars to build and support affordable housing. That's just not what the plan says.
So would it be fair to describe then the way Metro pitched this is, you have to understand the surcharge fund is going to be used in connection with many other funds to build out these other projects as part of an overall plan for how we'll move around Davidson County?
That's correct, Your Honor. And in that portion of the plan that we're discussing presently, that reliance is actually explicit. It talks about the fact that we're going to operate in conjunction with private developers to do additional work in these property spaces. So, and I believe that is what is contemplated in the what's intended in the Improve Act by its text, which provides for using these funds flexibly with other state, local, federal, and private funds.
I believe you said the funds could be used for both the acquisition and development of affordable housing.
Excuse me.
What
Sorry.
did you say?
No, I said they can be used for the acquisition and site preparation of property surrounding the regional transit centers.
But the development of it and the construction would come from some other sources?
That's correct.
All right.
And so what we're talking about there, well, first, it should be kept in mind, 1% of the total plan, those dollars, but the limit, what is intended there is a very limited, part of the development piece. It is the acquisition and preparation of the property, not the full-on acquisition. And so I think, look, if this was a plan that provided for building sidewalks that had no physical proximity or functional relationship to transit, that were miles and miles away from the nearest transit site, or if it proposed building housing in large quantities, I think that there would be an interesting claim to be made here. But that is not what the plan that was put before or approved by the voters is.
Is the issue before this court to examine the plan to determine what is and what isn't permissible and to excise or remove components of it? Is that before us, or what is?
I don't believe that is before this court, Your Honor, because what's before the court is whether Metro and through this transit referendum effectively levied a surcharge. The provisions that motivate the plaintiff's claims really go to how those funds are used downstream. And so I think plaintiff even conceded here in oral argument that there are certain uses that even under their, what we'd say a strained definition, are permissible. And so going to the authority of the tax, I think that is satisfied through the plaintiff's own concessions here. The real challenges under this theory would really come downstream about challenging specific expenditures that the plaintiff maintains are outside the scope.
Well, that's one of the things that worry me about this is that, well, then how does someone get standing then later to challenge something? Let's say Metro goes crazy and says, well, what we want to use this surcharge fund is to buy a home, buy a mass transit center for the director of WeGo, I don't know if there's a director of WeGo or not, but just hypothetically. And the taxpayer says, well, that's not a valid use of these funds here, and they go to court. The first thing Metro's going to say is, you don't have standing to challenge that sort of decision, because that's a entry that's common to every taxpayer in Davidson County. And so is there really an effective challenge if this does go off the rails and does something that's clearly, the example you gave is a sidewalk that had no connection to anything, maybe in a subdivision in a remote area. How would you challenge that then?
Well, absolutely, Your Honor. I believe that this court and Supreme Court have actually authorized an exception to those strict standing rules when there are that type of genuinely illegal use of taxpayer funds. There's a line of cases that provides for taxpayer standing, and as long as the person points out a specific illegality, makes a prior demand, and then brings the suit to challenge it. And so that is an exception to our standing doctrine that would allow such things to be challenged. And so, if a take it out of the transit context, if a city used its local option sales tax education funding to build a mansion for the superintendent, everybody would have there would be standing to challenge that illegal use of taxpayer funds, but it wouldn't be a challenge to the validity of the underlying tax. Thank you, Your Honor. I think those are the primary issues that we would raise. Look, we do believe that the primary function of election contest is, as was noted in the FOP case at footnote 4, to challenge the outcome of the election. And we don't believe that the plaintiffs have done so effectively here. There's no reason that people should lack confidence that this election occurred as planned, in the sense that there are no illegal votes, no illegal counting of votes, and even given the opportunity to put on evidence to demonstrate that voters were confused or misled, aside from the sheer legal disagreement that we have, there's no evidence presented to that.
So you are conceding that it's an election contest, though, right?
So I would say I am conceding that it is properly. Well, no. So I think it is an election contest that must be decided pursuant to the statutory proceeding. Yes.
I understand.
I will concede. If there's nothing further, Your Honor, I'm happy to. But because this was a lawfully conducted election that was fairly decided and overwhelmingly approved, and because Metro fully complied with the statutory prerequisites for passage, with the explicit ballot requirements that are set forth in the statute, and because this plan meets the straightforward and broad inclusive definition that is included for public transit system projects that's set forth in the Improve Act, Metro has complied with the law, and this is a valid ordinance that has been adopted, and we believe this court should affirm. Thank you.
Thank you, Senator Yarbrough. Mr. Clements, your rebuttal.
I'd like to address this notion that we have the TIP, the plan, and then all this other funding is going to come in and deal with those aspects of the plan that are not authorized under Improve Act. That's not what was represented to the voters, and that's not what the law allows. Under 3206, it says, before a surcharge may be imposed, a transit improvement program shall be developed and adopted in accordance with this section. So that was adopted by Metro. This plan, that's Exhibit 12 at trial, is what Metro adopted. And within this plan, it outlines very specifically the amount of money that's going to be spent and what it's going to be spent on. And it doesn't include affordable housing. There's a category that's places for everyone. And it outlines that Metro will build transit centers, and along with those transit centers, they will include affordable housing within those transit centers. So you can't have it both ways. They presented this plan to the voters and said, this is what you're going to get with a surcharge, and under the law, the surcharge has to be used for those projects that fall under the definition of a public transit system project.
So you're saying Mr. Yarborough was inaccurate in saying that the funds, the surcharge funds in regards to public housing would only be used for land acquisition?
Well, again, just reading their plan and what it says,
I am
would say that
asking
is
what your position
yeah,
is.
I would say reading their plan, that's what they represented to the voters. Now, they do reference in the plan on occasion outside funding or what have you, but this is what they presented to the voters that it would be spent on, and then it outlines it in the ballot language as well. So our position is that you can't have your cake and eat it too. You've outlined to the dollar what these projects are going to cost, and you've represented to the voters that it can be either funded by the surcharge or federal grants or state grants or bonds that are allowed to be purchased with the using the surcharge as collateral or whatever the source may be. It's outlined very specific in here. So, and I'd also like to address something Your Honor raised about whether or not this is fraud, and that's precisely, I mean, maybe fraud's a strong word, but it's our position that under the Rogers case, that the voters have to intelligently vote and understand the consequence of their vote in order for the election to be upheld. And in this case, they were told that the cost of the plan was $3.096 billion, but the actual cost is $6.9 billion. And that's over twice as much than what they represented to the voters, the cost of this plan. They put in the current cost. The current cost is not relevant. This is a 15-year plan. Actually, it goes up to, I believe, 25 years. But just looking at the first 15 years, only about $100 million is spent in the first 2 years.
Yeah, but isn't that issues that get sorted out in the democratic process here? I mean, Metro has their position on what this is going to cost, and the committee has its position, and then they both make their case, and then the voters decide.
Well, perhaps, Your Honor, but our position is the Improve Act requires that the current costs are put on the ballot. So that tells us that the legislator put great weight on the fact that the voters would want to know, what are we paying for here? If I'm going to increase my taxes, how much is it going to cost me? And the voters were misled and were told that it was only $3 billion instead of close to $7 billion.
Yeah, but I mean, when you're talking about billions, those are big numbers.
Yes.
And you still had a, 66% approval rate on this referendum?
Well, yes, and I would argue part of that is perhaps that the voters didn't know that it was going to cost them $6.9 billion. There's a reason that Metro only put the lower amount, the current cost, instead of putting the initial cost. The current costs are irrelevant to the ultimate cost of this project because as far as financial feasibility goes, what the current value is irrelevant. We need to know we have enough money when we have to pay for this 5, 10, 15 years down the road. That's the relevant cost.
The statute requires initial cost.
That's
right?
correct.
Well, it seems kind of logical to me that what it's going to cost right away or over the next year or two or three is the initial cost rather than the ultimate cost. For initial cost, you want them to say, well, through the whole 15 years, it's going to cost X. And they didn't put that. They put what it costs over a briefer time. And initial is not defined in the statute, is it?
No, it's not defined, but I think we have to give it its ordinary meaning is what is the initial cost of this project? And respectfully, what I would say is that means you have a project, you know what the elements are. What are the initial costs? We all know what happens with construction costs. As you go down the road, it gets bigger and bigger. So maybe there was something they didn't foresee. Maybe there's weather. Maybe the manpower costs more, the materials cost more. But today, we know as we go out 15, 25 years exactly what it costs. And I would submit that that is the important number in the taxpayer understanding what they're buying when they say we'll take a 0.5% tax increase, because that's the actual amount that's going to be spent. The current cost has no bearing whatsoever on the decision of whether or not I'm agreeing to have my taxes raised, because that number is meaningless.
When you were responding to the comment about, well, the surcharge is not going to be used for impermissible funding, you pointed to the plan, the Choose How You Move plan. Where would we look to find the direct tie between surcharge to inappropriate expenses? I mean, where would we find that linkage? Is there a budget number that we can go to and say, oh, if you look at this, you can see this surcharge fund is used for, let's say we've given the example of affordable housing, but.
Yeah, Your Honor, in Table A of Exhibit 12, it's very specific. It's even color-coded. You know, they have sidewalks, signals, streets, and safety are going to cost $1.3 billion.
Right, and yes, but I mean, they've got budgetary numbers for all that, but how do you know that the surcharge is going to pay for that cost, though?
Well, they outline that in this is page 8 of Table A of Exhibit Exhibit 12. I'm sorry. They outline exactly how much is going to be used how much of the surcharge will be used on the plan, and in this category from 2025 to 2039, $3.175 billion, or 46% of the project is coming, or the cost of the project is coming from the surcharge.
Is there any other than that document that you would point to that ties those numbers together?
No, they did a very detailed plan in here and outlined what all the money, I mean, it's outlined several times throughout the plan where the money is going to be spent and how much.
Thank you.
Thank you.
All right, thank you, Mr. Clements, and Senator Yarbrough. You have both given us a lot to think about, and we'll take the matter under advisement. That concludes the docket.